Good morning, and welcome to Best Practices for Working with Regulators During an Investigation. My name is Jonathan Pompey, and I am co-chair of the Consumer Financial Services Group at the law firm of Venable, based in our Washington, D.C. office. I've had the good fortune of representing companies in unfortunate situations, oftentimes in investigations before the Consumer Financial Protection Bureau, Federal Trade Commission, state regulatory agencies, and state attorneys general. And I, along with my team, have had some interesting experiences over the last several years, both good for our clients and ourselves, and in some cases, some fairly trying ones too. So whether it be something that leads to litigation or a closing agreement or something in between, the conversation today is going to focus on the investigation portion of what could potentially end up being an enforcement action. And today, enforcers and regulators are at their peak. There's no question that even at the Consumer Financial Protection Bureau, which there's a lot of discussion and myth about as to whether or not they're still active, I can tell you they're still active. We see that in our practice. In the Federal Trade Commission, which is speaking later today, state AGs and state regulatory agencies, they all have the ability to investigate companies. So we're going to take a look at both generically as well as, in some cases, some specific case studies. And even as companies that work through investigations and are faced with that, it's usually about defending practices, maybe interpreting the law, and there's a lot that can be learned from those experiences. So we've got a great panel here. To my right is Andrew Cosgrove. He's Associate General Counsel at Upgrade. Upgrade started in 2016, and it builds itself as an online lending platform on the premise that an online platform would operate at a lower cost and deliver a better customer experience than traditional banking. Now, that's from your website, so you might differ. But Andrew's been at Upgrade for almost a little over 2 years, essentially since the beginning, and before that was Senior Counsel at LendUp. And before that, in private practice at Skadden Arps, and before that as an analyst at Promontory. So you got the trifecta of consultant, outside counsel, and then
sort of a patchwork background that
well, at least
lends itself well to these companies.
Yeah, at least it's not backwards. I started in-house and then went to outside, so that's its own story. To his right and to my far right, Joby Danigan is here. Joby is General Counsel at HomeLight since 2018, so not that long.
No. Yeah.
But before that, he had been at two additional companies, at Credible and Syndeo. HomeLight empowers people to make smarter decisions during one of life's most important moments, buying or selling a home. So if you need a real estate agent or if you want to find a fast buyer, talk to Joby. But from 2011 to 2014, Joby was an enforcement attorney at the CFPB, and in fact was one of the first enforcement attorneys at the Bureau. And then he got out, though, and before that...
Before the election.
Hey. Was
You saw it coming in 2014.
That's a different panel, different conference. And before that, though, was at the Financial Crisis Inquiry Commission, which investigated, of course, the, quote, financial crisis. So you both looked at the past and then you charted the future when you were at the Bureau, and graduated in 2004. So we're just going to start with Andrew. Andrew, I want to start off with you. How does it feel to learn that an in-house client is under investigation? How does that typically sort of unfold if you're sitting in the shoes? And obviously, we don't want to talk about any necessarily specific experience. So these are all generic. And I guess I'll do the disclaimer for everyone. These are everybody's personal examples, not the opinions of their companies or
the agency.
The agency, right? Even though nobody here is from the agency. So those were other panels.
Yeah, so I think there are several different ways that an investigation can get started. The most typical, in my experience, is you go through routine compliance exams. I guess it depends on what business you're in. Both companies that I've worked for in the past 4 years do online lending. LendUp was a direct lender, so when I was there, we were in about 24 states. We had licenses in all those states. With those licenses comes regular supervisory examinations. And generally, when you undergo those examinations, the states are looking at your practices, your marketing, your lending practices. They want to see what you're charging the customers. They want to make sure that you're complying with the law. And in my experience, whether it's a state exam or a federal exam with the Bureau, or if you're a bank with the FDIC or the OCC, the agency will identify some things in those exams that they want to look further into, and that can lead to an investigation. As an in-house counsel, it's something that can happen, and you really have to look at it as a fact-finding mission by the regulator, and at the beginning, nothing more. If you have a good relationship with the regulators and you provide them the information that they're looking for, if you're doing things appropriately, then it can go away at that point.
And it may not even be surprising, because there could be the exam on the front end.
Well, that's sort of my point is, there are other instances where it can be surprising, but I think more often than not, it stems from an issue that was identified in an exam, and then they want to look more into what's going on there.
Right. So, Joby, let's go down a different path.
Sure.
You're sitting in a government agency,
Yep.
maybe with a lot of power, the ability to send out investigative demands, maybe with a slightly less than fully described purpose back in the day.
You're not bitter about that.
No. No clients were either. And you're thinking about dropping a surprise on a company.
Yep.
What's going through your mind? What work goes on before it even hits a company? A lot of folks in the audience are obviously in-house compliance, attorneys, executives. They get the envelope in the mail, maybe the voicemail that says it's on its way.
Yep.
But you're sitting there before that.
Yep.
Walk us through that.
Yeah, we look at several things. First, a company gets in the Bureau's Bureau's radar screen through tips from competitors, from consumer complaints, which we monitored religiously, from whistleblowers, from referrals from state AGs. And after that, we do our own investigation. We have investigators in-house. We look at the facts as stated, we look at the complaints, and then we look at the law. And we recommend an enforcement action if there are clear violations of the law. We also really look at the consumer harm, the gravity of the harm, how many consumers were affected, the extent of the consumer harm, and whether the company was being proactive in identifying that harm initially. If there's a specific product that keeps getting complaints, we certainly look at that when we examine and bring in enforcement action. And third, we of course look at the fundamentals, the company's compliance management system. How robust are your policies and procedures? Are these procedures actually living documents that you follow? Do you have controls in place such that when the regulator knocks, you have ready answers for those practices? We look at your training program. We look at whether you train on the regs we just rolled out. Do your loan officers, do your sales officers know about the TILA RESPA integrated disclosure rule, right? TRID, if you're in mortgage. Are they compensated appropriately? Do they know the new underwriting standards, the ability to repay a qualified mortgage? And finally, we really look at your compliance resolution process. Are you looking at the complaints? Are you addressing them? Because a complaint is essentially a canary in a coal mine. So if you have one complaint, there's probably 10 or 20 more. And you really need to look at that practice that's generating that complaint. If you're dealing in a gray area, if it's a new product that's innovative, be ready to, really read the regulation, read the commentary, read the supervisory findings, and also read the case law, the litigation surrounding that product.
And follow-up question. Now, you're talking about your bureau experience.
Yeah.
State agencies, the state attorneys general now,
Yeah.
they will bring oftentimes similar investigations.
Yep.
Sometimes companies, though, like to think of precedent, whether it be persuasive or mandatory, but these supervisory highlights and stuff like that, as being a silo, unique to the bureau.
Yep.
The states might take a different view, different position. What would your take on that be?
Can you frame it?
Like, in other words, should folks view past bureau or past FTC activity in a silo, or is it more about the type of activity in the company and the product and less about who was bringing the action in the past?
Probably less about who's bringing the action. So, as we all know, there's federal UDAP, which is enforced by the CFPB and the FTC. It's a fairly similar standard to state UDAP law. So whatever the Bureau finds is probably violating the state law as well. And as we all know, different state regulators they're different. Some state AGs are more aggressive than others. So if there's precedent from the FTC or the CFPB, I would look at that very carefully and have second thoughts about your product.
So, Andrew, yesterday, former director Richard Cordray talked about, I think, the Roman Legion and knights in shining armor and all sorts of stuff. CID comes over the transom or a recommendation out of an examination finding, says, we're referring this to enforcement. There's matters that require not just attention, but also maybe a gig. How do you mobilize internally? What do you view as being important? You heard from Joby all the stuff that they're looking at, but if you're in-house, how does that come together?
No matter what you're dealing with, I do think on the front end, it's basically a fact-finding mission of the regulator, and it can be fairly daunting to receive a CID or something very formal that scares everybody in the company. But really, at the heart of the matter is the regulator's looking for the facts. They're trying to find out, did you violate some law or regulation? Are you operating appropriately? Are you doing the things on the back end to identify the issues, fix the issues, deal with complaints, and all of that? So basically, I think the best practices are first to receive whatever the request is, sit down with the business folks that lead the teams that can gather that information, and come up with a strategy to gather the information, review it with the right people, and work with your counsel and your compliance folks to begin your response back to the regulator. And in the beginning, I said something about having a good relationships with the regulators. That's easier to do with the states because you have a lot of interaction with them if you're licensed through the states. I'm on the phone with state regulators several times a week. So if something were to come from the states, we at least have an open line of communication, and we've built some trust that they'll hear us out as to what's going on. With some of the federal regulators, it may be a little different in that the first time you may hear from them is in one of these situations. So I think you do what I said internally. Once you have the facts down and you start to prepare your strategy and your response, you get good outside counsel, you have good internal legal advice, and you make sure that your compliance management system is working the way that it should. And then you give the facts back over to the regulator, and you start working on, is the regulator comfortable with what's happening, or is there something more that you need to do as you move forward?
Mm-hmm. So, Andrew, you talked a lot about this fact-finding. Now, Joby, fact-finding makes a lot of sense. You got to mobilize. So, but when you were at the Bureau and then now being in-house, what do you view as important, not when the investigation happens, but day to day? How are you positioning, how would you run an organization? What tips would you have as to what are the important items to make sure that on a day-to-day basis are handled, in addition to the relationship that Andrew talked about, which I think is critical, but from your perspective, knowing both sides?
Yeah, absolutely. So Director Cordray, I love his analogy of a Roman fortress. I assume a lot of you watch Game of Thrones. I like to analogize it as protecting Winterfell from the White Walkers. Really having
not the Red Keep.
Yeah, the Red Keep. No, I'm talking about Winterfell from the White Walkers and the Night King. Essentially having several lines of defenses, getting ready for that examination, getting ready for that enforcement action.
Who's the Dothraki in this, though?
Yeah, lots of analogies that could go wrong here, but certainly having lines of defense such that when they do knock, it's not a fact-finding mission trying to find, what went wrong, finding the complaints, what they could be asking about, but really welcoming that regulator. What doesn't work is coming out with guns blazing if you get a CID, because that really could backfire. What you want to do is welcome the regulator, Have your CEO, your board of directors, sit in with the regulators, explain your compliance management system, explain your policies and procedures, explain your complaint resolution process. If there were things in the past that tripped you, definitely report it, be forthright, report your self-remediation, and have your fundamentals really buttoned up. I mean, there's, as Director Cordray mentioned yesterday, there's a baseline of compliance if you're in financial services. You need to have your policies and procedures, you need to have your training, and you need to have your compliance management system. A lot of us are in fintech, we're innovating, how do you fit a model disclosure on a phone? Lots of really novel interpretations of outdated regs of TILA, RESPA. So really have a ready answer, have a memo as to why you think what you're doing is not only innovative, pro-consumer, but actually within the confines of the regulation. And a lot of us deal in gray areas, but really have that defense ready if the regulator comes knocking.
Yeah, the questions of legal interpretation come into play too. I think that's a great example of not just making sure you have the facts together.
Right.
And certainly there's a lot of fact gathering that goes on very early in an investigation. Those first 10 to 15 days, maybe if there's an extension, the first 20 to 30 days, but making sure that both the in-house team and then the outside counsel, if there is one, are up on the facts to know where things could lead. Mm-hmm. But there's always this question of legal interpretation. I think particularly with fintech, even in non-fintech spaces, but when we had a situation once where the Bureau took an EFTA, Electronic Funds Transfer Act interpretation, that they had to roll back eventually later in a bulletin because it was so far out of what had been the classic interpretation of EFTA. So sometimes if you can't challenge the facts, sometimes you challenge the law. How much of that do you build in early on, Joby? I mean, like in other words, as you're building out compliance for startups, are you building out the legal arguments in addition to just making sure the facts line up?
Oh, absolutely. Again, if you're in financial services, you need to have a baseline understanding of RESPA, TILA, FCRA, ECOA, disparate impact. So you need to have that basic understanding. And as you innovate, really as a compliance officer or a GC at a small fintech player, you're interpreting regulations. You're looking at the commentary to the regulation. You're looking at case law. How are states construing this? You're looking at consent orders. Are there similar products? Is it the same fact pattern? And usually they don't really fit. That's why you have to have a basic understanding. You need to look at the statutory purpose of the statute, of TILA or whatever statute you're dealing with, find analogies, and if you do get questioned, and of course get a second opinion from outside counsel who's an expert in that regulation or statute, and have that ready answer if the regulator does come knocking.
I think there's a significant piece of fintech right now that's operating in sort of the grayer area. And you have to do these things to really make sure that you're buttoned up so that if somebody does come and ask, you've thought about everything. I think it's important to be able to show that you looked at all the regulations, you understand how you're interpreting them and how what you're trying to do fits. And everyone may not completely agree because it's a lot of time not black and white.
Now, Andrew, internally, when you're a supervised entity, in particular, you've got monitoring and testing programs, audit internal, particularly when you're a lender, and occasionally there can be blips, and so there's remediation that takes place. Sometimes not at the request of the regulator, but purely as a result of an active working compliance management system. In other words, that's actually the way it should be working as opposed to the way oftentimes it's reported, which is an agency found X and ordered Y. It should be the company found X, did Y, and then regulator saw that, and determined Z, right? So, but what value do you place on remediation? Oftentimes I know internal businesses will say, okay, do we have to do it? How do you counsel in that situation?
I think you have to look at everything that's going on and take the totality of the circumstances. In general, if you have a good compliance management system, you'll identify issues, whether it's through internal audit, or complaints. Consumer complaints are key to all of these businesses in that something could be going wrong that you don't even know is going wrong. And consumers will complain about it. And then when you see the complaint, you go and dig, and then you realize, okay, we did this thing. And I think the self-identification is key. And then the remediation piece is also key. And there's always sort of a balancing act when you're talking to the business about what needs to be remediated and what doesn't. And it sometimes can be a legal interpretation, and sometimes it's just common sense. But if something has gone wrong and you think you've created some consumer harm, if the regulator comes, the way I always describe it to the businesses, if the regulator comes in, this is one where they're going to tell us to remediate, so let's just do that ahead of time, document it. That way, if they come in later and they see what happened, you can explain, we have a good compliance management system, we identified this on our own, here's what we did to fix it, and here's what we did to remediate the potential harm. And I think that's the best case scenario. If you can get the company on board with doing that, it really saves you a lot of time when you go through your next exam and the regulator goes and looks at what had happened. If you don't do those things, they're likely to identify it, it'll create more questions, it'll tarnish the relationship a little bit, and then they're going to tell you to do the remediation that you already knew they were going to tell you to do anyway.
Mm-hmm. Now, Joby, earlier this morning I had a conversation with somebody and they said, I think I may be one of the few non-fintech companies present. Now, your company is certainly in the fintech space, but not a regulated lender like Andrew's. So wearing that hat of somebody who's working with regulated businesses or regulated individuals in terms of the finding of real estate agents and whatnot, but not actually in the thick of it yourself, how do you contend with that? And what suggestions would you have for companies that maybe are not under supervision and examination on a regular basis like Andrew?
Yeah, I mean, it's going to depend on your company. You need to know your regulators. And if you're, I assume a lot of folks here are non-banks, so you essentially have 50 regulators. If you're offering a consumer financial product, you have the CFPB. If you're doing any marketing, which we all do, you're regulated by the FTC. If you're offering securities, you're of course regulated by the SEC. So yeah, know who your regulators are. Be proactive. If you have a new innovative product, which I think a certain agency would be interested in, the CFPB has the Office of Innovation. Other federal agencies are very interested in innovation in the space, and I really don't see any harm in being proactive if you have a new innovative product that you want to get the regulators to sign off or opinion on. But in terms of my current job, yeah, we're regulated by the Bureau of Real Estate boards, but we are expanding the product suite. So, yeah.
Andrew, any suggestions? If you were to go sort of parachute into a company that was not licensed and didn't need to be licensed, but maybe had customers that were licensed, how would you build out? Would you think of this discussion any differently than we've talked about?
I mean, I think if you're following best practices, I think about things internally as what would a regulator say if they saw this, or what would a regulator tell me to do differently? And I think even if you're not regulated, you still have to worry about your marketing. There's still UDAP statutes everywhere and other things that you can get caught up in. And you have to think about litigation risk as well. So I think best practices would be to go about things in a very similar fashion. You don't want to be out there and seen as a predatory company that's preying on folks that maybe don't have, somebody representing them to protect them.
Or the North.
Yeah. The North. Yeah.
Yeah, maybe not the Dragons. Okay, we're coming up towards the end. Joby, for non-lawyers, as your counseling compliance staff, what tips would you give to compliance staff as to how to best not only deal with an investigation, but position a company and add value to what is oftentimes the dual relationship between in-house legal and in-house compliance?
The first and foremost tip is just be ready for an examination, for a CID. Have the baseline fundamentals, policies and procedures, complaint management system, training. Know your regulators. Know who your key players are. Be a good business partner to the CEO. as a small GC, for example, you're dealing with compliance for the entire company, not just for the financial piece, but you're dealing with marketing, with CMO, making sure that UDAP issues are addressed. You're dealing with the engineering team, making sure that your info security is up to par, that you're protected, you have the adequate insurance against cyber attacks. Everyone gets hacked these days. You have product counsel for the products that you're innovating in, making sure that issues such as ECOA and all these regs are being addressed when you're building out a product. You're dealing with a CFO, for example, given that if you're a financial services company, you have net worth requirements and you have reporting requirements to HUD, for example, or to your state regulator. And of course, dealing with the CEO and the board, really emphasizing the importance of compliance to the CEO and the board of directors, having sort of that regular rapport, having regular reporting, because it's a huge exposure, especially as the company scales.
Andrew, any tips?
I think those were all really great tips. One thing that wasn't mentioned was employee training programs to make sure that all the employees are up to date on different regs that may apply or other things that they should be doing to make sure that consumers aren't being harmed.
And I'd like to add one other sort of tidbit before we close. But if they do come knocking at the door, cooperate, be honest, be proactive, welcome them in, welcome that chance to show your compliance management system. The last thing you'd want to do is come out with guns blazing, because regulators are people too. They have feelings. So they have prosecutorial discretion. So if you come out guns blazing, very adversarial, they have all the power. So it's just a thing to know.
I would just
tips of your posture.
add that I think probably 5 to 10 years ago, the thought in Silicon Valley in the early fintechs was move fast and break things, and then if the regulators come in, we're smarter than them and we'll just fight them and we'll win. And we've seen over time that absolutely doesn't work. It's probably the worst thing you could do. And we've seen a shift over the past 3 to 5 years from that mindset to the mindset that we're sort of talking about up here, and that have good compliance, have good legal people, and be prepared, and really create good relationships with the regulators, and you'll get the best shake. And I think that's what's happening now.
Well, on that note, we'll wrap up. I want to thank our panelists for the great conversation today, but also really good tips for the audience. I'd also like to invite everybody, of course, to use what they've learned today in day-to-day practice, and certainly thank the folks here at Performline for Comply. And it's now this 5th year of conference, and it just keeps getting bigger and bigger every year. So I think we'd all agree it's been a terrific event and continues to be a lot of value for everyone here. And with that, thank you very much.